The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon, and welcome to council and to all those of you on our YouTube channel. We welcome you to this historic session of the Kansas Supreme Court, as today is the first day as we sit with our new colleague, Justice Melissa Taylor Standridge. I will ask Mr. Doug Shima, the clerk of the appellate court, to please call this afternoon's 1:30 docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Monday, December 14th, 2020 consists of one case. Appeal number 121720, State of Kansas versus Dylan Barber, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Corey Call, appellate defender, representing Dylan Barber, ready for argument.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel. Mr. Cole, you may begin.
Thank you, Your Honor. Dylan Barber in 2018 drove from Emporia to Wichita, Kansas, and killed his girlfriend. He then called 911, reported the crime, and the police showed up, had their cameras on, talked to him. This was never a case about whether or not Mr. Barber killed Mackenzie Payne. Shortly after, Mr. Barber was appointed counsel, and he told counsel that about a week before he had killed Ms. Payne, he had been on prescribed some antidepressant medications. And his attorney then talked to a psychologist, came back and said, that's not going to be a defense for premeditation. Mr. Barber subsequently pled guilty to first-degree murder, and then prior to sentencing, moved to withdraw his plea. The basis that we're talking about today is that his attorney did not adequately investigate the effect of the medications on his ability to premeditate. And as I said, the attorney talked to a psychologist. Frequently in these cases, the attorney doesn't investigate at all. And here the attorney did, but the attorney was very specific. And when they're talking about that conversation, that they spoke about the physical effects. The psychologist said that it would make Mr. Barber sleepy or drowsy, but that when asked, well, what were the mental effects of this medication? The attorney said, I couldn't tell you. And they hadn't discussed that, he said that was really what the case was about. And the district court, in denying the motion to withdraw his plea, again, relied on the physical aspects that were available to the attorney, that the attorney was able to watch the police officer's video and see that Mr. Barber was lucid, and that you had these conversations with the psychologist. And those would be fine factors if this were like an alcohol voluntary intoxication case, where frequently there are physical manifestations to the intoxication, the effect on the brain. But here we're talking about antidepressants, and that's not always clear from physical appearance that the attorney would be able to say this had no effect. And so the question for this court, I think, is to what extent does an attorney have to investigate in order to satisfy the strategy exception, that he investigated it and he determined it wasn't a valid defense, because attorneys are not required to raise all their defenses, but they're required to investigate it. And Mr. Barber relied on that representation of defense counsel that, no, this isn't a good defense. And then he pled. And I think it's also important to note that we're talking about a pre-sentencing motion to withdraw plea. The state below said that this is just buyer's remorse. And I think that's a more difficult argument to make when it's pre-sentencing. This isn't a case where he made a deal to get a particular sentence, didn't get that sentence, and then said, oh, I want a different deal. I want to go back on my end. This was prior to sentencing, and the standard is good cause. Is it good cause for Mr. Barber to withdraw his plea that he was told that's not a defense? And again, this wasn't a who committed the crime thing. His defense, his only hope for going to trial was to mitigate his mental state, or to attempt in some way to get a lesser charge than the first-degree murder, which carries a hard 50.
Mr. Call.
Yes.
Mr. Call, what's your theory of what the defense attorney should have done in this case?
Well, I think when the attorney was speaking with the psychologist, because the issue is did the antidepressants affect his mental state? Then you asked the psychologist that question. And if the psychologist, I mean, I guess I'm not the best person to know if psychologists are trained in medications. I assume this one was because they talked about it. And that he listened to but specifically asked the psychologist, what was the effect of this medication on his mental state? And then he could make a reasoned opinion, a reasonable recommendation to Mr. Barber on whether or not it affected his mental state.
And why isn't that more or less what actually happened here?
Well, as I read the defense attorney's questioning, he asked, how would this medication affect Mr. Barber? And what how the psychologist responded was that it would make him sleepy, it would make him drowsy, and talked about the physical effects that would have, as opposed to
why isn't the question, how would this affect my client? Why doesn't that encompass any potential mental effects?
Well, it could, I think, but when the key question in the case is your defendant's mental state, and the psychologist only gives answers regarding the physical state, I think it's incumbent upon the counsel to follow up and say, well, are there any mental, would this affect his ability to form premeditation? Would it affect his mental abilities? Because that's what the question is going to be. You can ask the right question, and that could be the right question, but if you get an answer that doesn't get at the heart of what the attorney needs to know and what the defendant needs to know when he's entering his plea, then you have to ask a follow-up question and get the answer that actually goes to the heart of the defense. So that was the one claim that we raised, that Mr. Barber relied on that advice of counsel, which was not properly investigated. And we would ask this court remand to the district court and allow Mr. Barber to withdraw his plea.
I guess I'm confused. What evidence is there in the record that there is some sort of, you're trying to differentiate between physical effects and mental effects, and what evidence is there in the record that this medication that he was on could possibly have mental effects that would not be discernible by looking at the physical effects?
There was not, as I read the record, I did not see testimony about what the actual effects, other than what the only discussion of the effects of the medication were the attorneys talking about what the psychologist told him for the physical effects. So I do not believe it was well developed in the record that there would be psychological effects.
Why isn't that fatal to your argument? Because if you're trying to say he didn't ask a question, don't you also have to be able to say that there was an answer that would have been meaningful to the defense of Mr. Barber? It certainly would have been helpful to the case to know that it would have it would have had an adverse effect. I do think that the problem for Mr.
Barber is that he entered a plea without having the proper knowledge, without knowing that it affected his mental state. Unless this court has any questions, I would ask that you please remand.
Any other questions? Thank you, Mr. Cole. Ms. Isherwood?
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. The single issue before the court this afternoon is whether the district court abused its discretion when it denied the defendant's pre-sentence motion to withdraw his plea. In order to obtain the relief that he seeks, the defendant bears the burden of establishing that no reasonable person would have reached the same conclusion as the district court. Edgar lays out the three factors that generally provide a framework for an analysis of this issue. The defendant has focused on the first of those factors, which is whether he was represented by competent counsel. He has then chosen to narrow that issue further by arguing that counsel did not provide competent representation in the manner in which he handled the information regarding the fact that the defendant was taking an antidepressant starting a week before this murder occurred. Defendant argues that the defendant reached a conclusion regarding the effects of that medication without first conducting a reasonable investigation into the same. However, what was demonstrated at the evidentiary hearing and what is preserved in the record before this court is that defense counsel testified that he received a portion of the defendant's medical records as part of discovery, which included the medical records from Simmons Medical Center from where this prescription was issued. He then investigated the medication that the defendant was taking and the corresponding dosage. He made contact with a psychologist about the medicine who not only was learned in his field, but also had considerable exposure to the criminal justice arena and was familiar with the theory of voluntary intoxication. That expert advised counsel that no, this medication would not provide a foundation for voluntary intoxication because the only notable side effects are that it would leave the defendant feeling sleepy or fatigued. That is, it does not give rise to the type of effects that would allow for a voluntary intoxication argument. As noted by this court, there was not a counter to that offered at the motion to withdraw plea hearing. In addition to that information, defense counsel had the opportunity to review the Axon video. He saw the manner in which the defendant interacted with law enforcement immediately following the murder. He reviewed the 911 call, which also displayed defendant's even temperament and lucidity. And he was also aware the defendant had the wherewithal to contact his brother immediately following the murder to confess to what it was that he had done. Now, while the defendant may have believed that he had an effective counter to the premeditation theory, counsel, with his 3 decades of criminal defense experience, coupled with the inquiries and the investigation that he had conducted, concluded that the defense was not viable under the facts of this case. Now, the defendant would like to have this court analyze the issue by honing in on a very particularized factor and seemingly turning a blind eye to all other components of the case. What provides a more accurate assessment is a bird's eye view of this entire case. And what that perspective reveals is an evolution of thoughts and claims that reveals the defendant's position currently for what it actually is, and that is buyer's remorse. At the plea hearing, the defendant acknowledged his culpability for this crime. At the evidentiary hearing, he testified that he chose to enter this plea to shield his family from the details of the crime that he had committed, to avoid having to see pictures of Mackenzie lifeless in the death that he had caused, and to afford her family some degree of closure. However, upon returning to the jail, his fellow inmates questioned why it was he had entered the plea. Additionally, in discussing the plea with his family, they likewise questioned his wisdom in entering a plea. That planted the seeds of doubt with the defendant, which then culminated in his first motion to withdraw plea filed pro se, that simply stated that upon reflection and discussion, he had determined that this was not in his best interest. Once counsel was appointed, that claim took on a new characteristic, and it was now that he needed to withdraw his plea because counsel had not conducted any investigation. That issue has now evolved further into counsel did conduct investigation, but it fell short. Defendant assured the court on more than one occasion that he was only entering this plea because it was his voluntary choice to do so, and he should be held to that decision. At the end of the day, what remains is that defendant carefully calculated and premeditated Mackenzie's brutal murder. He educated himself to ensure that the stabbing was lethal by severing multiple arteries, and then drove from Emporia to Wichita and waited in her parking lot for 20 minutes before entering her apartment and carrying out the precise violent attack that he had planned. He has failed to carry his burden to demonstrate that the district court's decision was arbitrary or unreasonable, and that no reasonable person would have likewise denied this motion. And for those reasons, the state would respectfully request that this court affirm the decision of the district court.
Are there any questions of counsel?
Also, there was some, at least in the record, argument about the qualifications of a psychologist to render an opinion on medication and whether they have even prescriptive authority in our state. Can you comment on that? And what would your response be in terms of record support for the qualifications of Dr. Steffens?
Dr. Steffen, my understanding is he is a doctor of psychology, and that he is very learned in that field. He has been qualified as an expert multiple times in this jurisdiction. So that would be my understanding. He was not called as a witness at the time of the hearing. So all we have is the testimony from counsel that he is in fact a doctor of psychology. This is someone that counsel has worked with for several years with respect to any questions surrounding issues of that nature, and that he has been qualified and an expert in Sedgwick County for a number of years.
Other questions? Thank you, Ms. Isherwood.
Thank you, Your Honor.
Mr. Call, you reserve 3 minutes.
Unless the court had any question, I would waive rebuttal.
Any questions? Don't see any. So thank you to both counsel for your arguments today. We will take this appeal under advisement. Court is now in recess.